Good evening to everybody. Welcome to the class of the Advanced International Law that we are dealing with the foreign judgment, recognition of the foreign recognition and enforcement of the foreign judgment. And please see that what I posted on the screen. Could you tell me that what its name? It's not a hammer. It's not a nondo. Of course, it is with the auctioneers and it will be with the magistrate or judges. It will be there. Am I right?
Yes, Professor.
And its name is, there is a specific name is there. Now you could see in this screen. Did you see what it is there in the screen? What the name is there? Read. Unmute and read, anyone.
It's called the Gevo.
Next.
On top, one tap of the Gevo follows the announcement of.
When I say next, what about this one? This one, this one, this one. This is a gavel. What about this one?
Sounding block.
Yes. So this is a gavel, this is sounding block. Where it will you find it? It the judges and magistrate and the auctioneers. When there is any disturbance should be there, when there is a nuisance should be created, or the time at the court they will bang it 3 times by the judges. But the auctioneers, of course, it is a 3 times, but not necessarily the 3 times in the judge and the magistrate. Even 1 time also it will be enough to draw the attention of the people that they are creating the nuisance in the court. So anyway, that now the participants are joined total. Yes, total 3 are there: Darko Zizay, Macman Lehman, Raymond Cosmos. Now, without the wasting the time, let us go to the last class where we are discussing. We are discussing this Richmond Dons versus Tedesco case law. And this is on the screen that I have shown you. What I have shown you on the screen? What do you show on the screen?
It's Adowan's power plant site B.
It is a site B plant. It's a Richmond Dons private plant. A also there, it seems, because when the site B is there, naturally site A should be existence over there. And there is a contract between the Richmond and the Tedesco regarding the selling of the what? Vyazi or Bamia?
Yes.
What? What is the selling of what?
Electricity power.
Yes, electricity or the power. Huh? So that was a contract would be there. So when the Tedesco made the breach of a contract, at that instance, the Richmond Dawan filed a case in the tribunal. Because in the contract itself, it is clearly mentioned that if any case of the dispute would be there, ICC. And what is the ICC? That we will see it here. So in the landmark case, Richmond Dons versus Tedesco, this is not the proper style of writing. It is the old style of writing. What is the proper style of writing? Whether you know it, you tell me. If you don't know it, you say pass on.
In italic font.
It is italics are there. Yeah. Yes, it is italics. Next. What is not proper way in this case law, which I wrote here?
Professors.
What should be written there?
Richmond Dowans V.
Yes, it's only the V. The new style is V, only V. Yes, Tedesco. It is already in the italics. So this is the right way of writing. After the comma, of course, the citation is there, which will go to the footnote. Okay, now let us see that the defendant Tedesco applied to the High Court to have an international chamber of the commerce. There is the ICC arbitration. It is clearly written in the case of the breach or if any dispute would be there, and the ICC arbitration award and the ICC arbitration where the case would be filed. It is a tribunal. So the High Court dismissed the application, stating that once the party had submitted themselves to the arbitral process and one party could not challenge an arbitral award. Simply, it did not yield a favorable result because Tenesco and the Richmond, they made an agreement of the sale of the electricity. In case of any dispute would be there, the tribunal is there, ICC arbitration tribunal will decide the case. That would be agreed by the parties. But here, when the Tenesco, of course, the ICCT arbitral award is given in favor of
Richmond.
Richmond, then agreed Tenesco what they failed it no, and Tenesco agreed by the decision of the that is ICC arbitration award, and Tenesco filed a case in Tanzania in the High Court. So that is the thing. So when the High Court dismissed the application of the Tenesco because it is already clearly mentioned in the agreement itself is there. If in any case of the dispute would be there, ICC tribunal will delete. When the tribunal has given in the favor of the Richmond Dons, the agreed party cannot approach to the High Court, and the High Court rejected it. Okay, when they can approach to the High Court when there is a error clearly there in the award. At that instance, one can approach to the High Court, the Tenesco. And the Tenesco appealed to the Court of Appeal because it is not given in the favor of the Richmond only, because the award is a proper award and that should be followed. Where the Court of Appeal upheld the High Court decision to enforce the foreign arbitral award, which was issued by the International Chamber of the Commerce of England, holds and binding on the parties as they agreed in the contract. So, what was the agreement? It is there between the Tenesco and Richmond. Number one, sale of the electricity. Number two, in case of any dispute, yes, unmute and give me
The
the
International
answer.
Chamber.
Yes, it is the
In
International
case
Chamber
of
of
any
the Commerce Tribunal is having to deal the if any dispute would be there between them. So here, of course, I tapped from it, and can you read the background? Haraka, haraka, quick. Anyone?
background, Richmond submitted a request for arbitration at the International Commercial Court (ICC) Tribunal in September 2008. The claim amounted to USD 169 million for allegation, defamation, and damages for the termination of the agreement. The matter was held in April
Not held.
2010
The matter was heard.
was held in April 2010 in Dubai. Similarly, Doan submitted a request for arbitration at the ICC Tribunal in November 2008, claiming damages for alleged repudiatory breach of contract and for partially unpaid capacity charges. The claim amounted to USD 149 million. The case was heard in June 2010 in Dar es Salaam.
It is very self-explanatory. Who approached the court, where it is happened, and how it can be made. Is it clear?
Yes, sir.
It is self-explanatory. You don't need any explanation in this regard. So the tribunal's award, let us see. Another person can read what is the tribunal's award. Another person. Unmute and read.
The Tribunal's Award 1.1 Arbitration Matter Number 15910 stroke VRO RDE VCO LLC Richmond Development Company USA versus Tanzania Electric Supply Company Limited. Richmond's claim amounted to USD 169 million. Tanesco has successfully won the case and has been awarded USD 1,201,933.08 million, being 50% of Tanesco's legal and other costs, while Richmond was awarded USD 50,000 United States dollars only for defamation claim against Tanesco.
Yes, because who made the breach of contract here? In this case law, who made the breach of contract here? Is it a tough question which I asked? Tanesco made the breach of contract.
Tanesco.
And Tanesco could not having the money to pay to the rich man. And that they made the breach of contract. That's why it is already clearly written in the contract that if any case of the dispute would be there, it is the ICCB tribunal or the court, commercial court, will having the jurisdiction to entertain it. And it is made the arbitration award also in the favor of the rich man. Yes, the Tanesco should have to supposed to pay the damages. You cannot remember the figures. Hence, we can say that Tanesco is supposed to pay the damages for the breach of a contract the tribunal has given. So next arbitration matter from here, another person could unmute and read. Another person could unmute and read.
2.1 Arbitration matter number 15947/VRO between Dowans Holding SA Costa Rica and Dowans Tanzania Limited versus Tanzania Electric Supply Company Limited, TANESCO, shall pay the sum of USD $24,168,343.83 plus simple interest at 7.5% per annum on the aggregate principal sum of USD 19,955,626.71 from 5th June 2010 to the date of payment.
You cannot remember the dates, you cannot remember the figure. Then the what you have to write the gist is the arbitration award made it the damages that the Tanesco should have to supposed to pay the damages with the interest of the 7.5%. That much is enough in your writing. Because you cannot know the figures. And figure is not that much important. The gist is important. Damages should be paid by the Tanesco to the Richmond Dons. That is more important factor. So next person can read what is this one. Quick.
Tanesco shall pay the sum of USD $39,935,765.50 plus simple interest at 7.5% per annum on the aggregate principal sum of $36,705,000 and 13.94 from the 15th June 2010 to the date of payment.
Yes, that means 7.5% plus the damages should be paid by the Tanesco to the rich man because the Tanesco made the breach of a contract. So Tanesco shall pay to the Don jointly the legal and other costs the amount of the $1,785,121 US dollars. That means 7.5% plus the damages should be paid. And who made such a tribunal award? Who made such a tribunal award?
Dowans.
ICC. Tribunal award, it made it. Where is the ICC? Commercial Trial Tribunal or Court? Monza. The ICC Tribunal Court is in the Monza. Is it right?
No, Professor.
Where it is? We already read it, but you did not notice. England. Where it is? Say, England.
England.
Very good, very good. So now let us see what are the circumstances a foreign judgment conclusive. And we already told you the apex court should have to make it out. Number one, if the chances of the appeal would be there, it is not conclusive. Number two, or number three, it should not be against the public policy of that country where it is implemented. Means enforcement of the recognition of the foreign judgment. Number 3. Number 4, it should not be contradictory with the existing laws, including the Constitution. What do you say another name for the Constitution? What do you say another name for the Constitution according to the Kelsen theory? If I not be mistaken, if you know it, you tell me. If you don't know it, you say pass on. Don't waste my time.
Pass
Law
on.
of the
Another name for the, according to the Kelsen theory, is Constitution is Grand Norm. Grand, G-R-U-N-D, Grand, N-O-R-M, Norm. Grand Norm means it is the hub of the all the statutes or the country's things where the country can be ruled and how it can be made regarding the executives, legislative, plus executive, legislative, plus the 3
court
organs,
decision.
not court decision and judiciary. Say now 3.
Sherry.
Say now 3 organs of the Constitution where it runs the show. What are the 3? Just now I told you. Number 1, executive.
Executive.
Number 2,
Legislature.
number 3,
Judiciary.
yes. So that is the thing. In private international law, parties are at liberty to choose the law governing their underlying contracts, at the same time choose the forum of the dispute resolution. So now the party is given the full liberty to choose any country law or the court when there is a breach happened between their contract, even though the party not hailing from that country. Suppose Tanzania, one of the party, the another party is India. They can make even the UK law or the court where the dispute could be entertained. Is there any objection? Is there any objection?
No.
Answer is no.
No, sir.
If the party is having the liberty to choose the law governing their underlying contract, at the same time choose the forum of dispute resolution, the principle also recognized on the laws of Tanzania. So this principle is recognized in the law of Tanzania, means parties can choose any country law even though the party not belong to that country. Is it clear? Say yes.
Yes, sir.
Good. Before embarking the subject of this write-up, we crave to point out there is a distinction between the enforcement of the foreign judgment and the enforcement of the foreign arbitral awards. We need not do that much worry about it because both are, one is award because it is a tribunal, another is a judgment because it is a court. Are you following me? Who gives the award and who gives the judgment?
An award is given by tribunal and the judgment is given by court.
I appreciate. Well, so now let us see that in cross-border financing transaction, wherein keys of the borrower is from the Tanzania and the lender is from outside Tanzania, let you presume India. The governing law at the dispute resolution forum is the matter of the financing documents, and the lawyer is in Tanzania are normally asked to provide the expert advice. Suppose one party from Tanzania, another party from India, they can choose any country law as their dispute resolution because the liberty is given to them. Typically, foreign lenders, in order to hedge the potential risk, prefer the governing law of loan documentation other than the security document. So here the money matters are concerned. Generally, it is the plaintiff will be given a chance and where the dispute would be there and that country law would be applied. Because the plaintiff stays in Tanzania, at that instance, he cannot make as the dispute resolution there in the India, and he can also not make the dispute resolution or adjudication of the case in UK. The reason is the plaintiff is well established their business in Tanzania, having the house in the Tanzania. The forum convenience is Tanzania. That is called, what is the terminology we can use in the private international for the forum convenience? Forum shopping. What do you say? Forum
shopping.
Is the who will be given the forum shopping discretion or the interest? It is the plaintiff to the given to the forum shopping idea. So a question arises in the scenario where there is a dispute with respect of the financing documentation and the lender takes a dispute foreign court. Will the judgment of foreign court will be enforceable in Tanzania against the local borrower? The answer is, if the general principles are the same, and to avoid the dispute taking time, once decision of the another country can be as it is used in the law of the forum, because the two countries having the either the treaty or it is the reasoning of the judge to decide it. Enforcement, recognition and enforcement of the foreign judgment. Because we already said one of the thing. What is there? There is no hard and fast rule. We read this one. There is no hard and fast rule is there to decide the private international law cases. It is the discretion and the reasoning given to whom? The reasoning and
Judge.
judge, that is the judge it will be given. So answer to this question is found squarely in the Reciprocal Enforcement of the Foreign Judgment Act, Chapter 8, Revised Edition 2019, the laws of Tanzania. There it is clearly mentioned there, when there is a reciprocal agreement would be there, and they are the parties to the Reciprocal Enforcement of the Foreign Judgment Act. At that instance, those countries will be followed the enforcement and recognition and enforcement of the foreign judgment. So now let us see that the Act makes a provision of the reciprocal enforcement of the foreign judgments as between the mainland of Tanzania and the foreign countries, and for the related matters. In which matters is recognition enforcement of the foreign judgment? Only in the civil matters. In the criminal matters, what will happen? If there is extradition treaty is there between the two countries, at the time the criminal matters will be handled and the perpetrator is run away from the Tanzania, for instance, we take, and taking the asylum in the, say, Botswana. If the Botswana and the Tanzania having the extraditional treaty would be there, then the perpetrator would be handed out by the Botswana to the Tanzanian government, if it is a criminal matter is there. So this means that only judgment of the court of the country which has a reciprocal agreement with the Tanzania can be enforced in Tanzania in line with the terms of the Act. Whatever the terms would be there in the Act, when there is a reciprocal agreements are there between the parties or states, at that instance, enforcement of the recognition and enforcement of the foreign judgment could be made in other country. Other countries' law could be made in the forum shopping, where the case is filed. The process of recognition of the foreign judgment occurs when the court of one country or jurisdiction accepts the judicial decision made by the court of another foreign country or jurisdiction without rehearsing. See the point very clearly. See what they highlighted is, they say, without wasting the time, without rehearsing the substance of the original lawsuit again. In the circumstances, once a foreign judgment is recognized, the party who was successful in the original case can then seek its enforcement in the recognizing country. To whom that you have to apply? Suppose the foreign judgment will be enforced in Tanzania. Of course, it comes from the embassy to the foreign exchange minister from that country where the judgment is passed. From there, it comes to the embassy of this foreign minister. For foreign minister, it goes to the registry, and the registry will see that where the case will be entertained in the High Court or in the District Magistrate Court. Of course, generally District Magistrate Court or the Resident Magistrate Court matter will not come over there. It is the High Court where you have to give the notice. What is the limitation period? For the foreign judgment which is given in the other country, for instance, take Tanzania, for Kenya or India. What is the limitation period we said?
6 years.
6 years. I appreciate. See, I highlighted this very, very important. Anyone can unmute and read, which are highlighted in the red color. Yes, anyone?
Countries that enjoy reciprocity treatment under the Act are limited to 11, namely Botswana, Lesotho, Mauritius, New South Wales, Zambia, Seychelles, Somalia, Zimbabwe, Swaziland, United Kingdom, and Sri Lanka. As a result, it should be well noted that not every judgment of a court from a foreign country will be enforceable in Tanzania.
That means whichever country which is having the reciprocity under the act with the Tanzania, only 11 countries should be there. Namely, of course, namely can be also written as, anyone? How do you write the namely?
Known as.
How do you write the namely in another terminology? I will write here. The namely can be written, for instance, namely can also be written, let me say namely is written also like the shortening form, VIZ. Videlicet. What is the full form of it? What is the full form of it? Which full form? VIZ full form. Here it is given. What is given? VIZ, read. Read.
VIZ is an abbreviation of videlicet. Videlicet, which itself is a reduction from the Latin phrases of videre licet, indicating it is permitted to see. It is used as synonymous for namely, that is to say, to wit, which is, or as follows.
Yeah, namely means, that is to say, to wit, which is, or it can be right, videlicet is the full form of it, that is the shortening form of the viz. VIZ. V is a capital letter, I is a small letter, then Z is there. So namely means VIZ. V capital letter, I small letter, Z small letter, full stop, comma. Do you know before this namely can be also said as a viz? Anyone? Please say frankly.
No, Professor.
All of three should have to give the answer. Number one has given the answer. Number two?
No.
Number three?
No, Professor.
If you miss my class, you miss not only the subject, many other things which are supposed to be known to a student of private international law. Not only private international law, any student of law. So how many countries are there? 11. What are they? Botswana, Lesotho, Mauritius, New South Wales, Zambia, Seychelles, Somalia, Zimbabwe, Swaziland, United Kingdom, and Sri Lanka. There is no India, there is no Uganda, there is no Kenya, there is no Burundi. Are you following me? Are you following me?
Yes,
Of
sir.
course, they do have their
Yes,
own
yes.
understanding because these are all called East African countries. Is it or not? Is it or
It is,
not?
Professor.
Yes. So looking
It
at the
is.
list of these countries, apart from the United Kingdom, there is an insignificant trade flow between that Tanzania, because generally Tanzania is having very good relations in the commercial matter, trade matters, export and import matters with the which countries? Anyone? It is already there on the screen.
China.
China,
Germany,
Kenya,
Germany, Japan, India, but I
United
think
Arab Emirates.
and I think United Arab Emirates also comes over there, and the European Union also comes, and we do have the good relations with the Kenya and other countries. Even from the Philippines also there is some Philippines, South Korea. Yes, some relations are there. Thailand, of course, but the major is China, Germany, Japan, and India, plus United Arab Emirates and the European Union, some of the countries. So that is the relationship would be there, but it is not included in the 11 countries. So registration of the judgment, already told you that 6 years before that judgment should be there, and it should be registered with the High Court of Tanzania. Who will register the High Court of Tanzania? Who will register at the High Court of Tanzania? The party which wants to see that foreign judgment would be implemented in forum shopping, that party will make the representation and registration it can made in the registry of the High Court of Tanzania. Is it clear?
Yes.
Yes.
Just read the last point. Enforcement of the foreign maintenance order. Anyone? Oh! There is a spray. You mute it. Your household talks. I could hear. Yes. Anyone can unmute and read enforcement of the foreign judgment. This is one of the example. Yes.
Enforcement of foreign maintenance orders. I, say Irene, was married to a Tanzanian. Our
See,
marriage was contracted in the
just a
United
minute. Just a
Kingdom.
minute. Just a minute. After there is something I made it here. This highlighted. What do you say? This thing. After this thing and this thing. What you
Open
call that?
brackets.
Professor Hussain students will not say bracket because there are 4 types of the brackets are there. How many types? Brackets are 4 types of the brackets are there. Of course, here I can show you another way. There are 4 types of the brackets are there. What are they? Number 1, this is called, this bracket is called, generally, Professor Hussain students will say, not say in that way. It is a round bracket or circular bracket But Professor Hussain students say, Hussain students, what they say? Parenthesis. Parenthesis. So now you tell me, what the Professor Hussain student says?
Round bracket or circular bracket.
No.
But Professor
Hussain students will not say round bracket.
says parenthesis.
Professor Hussain students will not say circular bracket. Professor Hussain students say parenthesis. What do you say?
Parenthesis.
Parenthesis. Sir, are you telling the truth or are you telling the wrong? Okay, I will prove it. Because here I will say what is the parenthesis. Of course, spelling a little, I made the mistake in the spelling, it seems. Oh, this is not parenthesis. Parentheses. No, RA, no, RE. What is written? What is meant by parenthesis? Read. Quick.
A word or phrase inserted as an explanation or afterthought into a passage which is grammatically complete without it. In writing, usually marked off by brackets, dashes, or commas.
So in generally, this is one of the bracket where I want to show you. The another type of the bracket is either you can say curve bracket or you can say this bracket is curve bracket or flower bracket. And this type of bracket is, tell me quickly, this type of the bracket is quick. Square bracket. And this type of bracket is, this type of bracket is quick.
Pass on.
It is the angle bracket. So how many brackets are there? Round bracket, circular bracket. Professor Hussain students will not say like that. They say parenthesis, then the flower bracket or curve bracket or square bracket or angle bracket. So now let us go back to our studies. So I say Irene was married to a Tanzanian. Our marriage was contracted in the United Kingdom, and I ended having the matrimonial dispute which ended up in the court in the UK. The UK court granted the judgment and divorce order for my former husband, that is Irene, to pay the maintenance allowance to me and 3 children. And after that, immediately after the court issued the decree, my former husband left to travel back to the Tanzania and working in the multinational company in the Tanzania. Then how the judgment of the UK would be implemented in the Tanzania? So section 141 to 144 of the Law of Marriage Act clearly says that there is a reciprocal is there, because UK is the one of the party in the Tanzania among the 11 countries. Hence, for the foreign judgment, from that ministry to the external affairs to this ministry, from the external ministry to the High Court could be registered over there. Then the High Court will implement the judgment of the UK. Why? Because UK is among the 11 countries with the Tanzania. Am I right? Am I right?
Yes.
So, of course, process of registration, we know it, 6 months. How the registration is there? The court decision should not be more than 6 months. And to the foreign ministry, to this ministry, from that ministry to the High Court, and notice will be given over there. So this is the type of the registration we can already studied over, and this is the repetition. But I would like to show something. What is the foreign judgment? You could also see and hear what it says about the foreign judgment. So let us see where it is gone. Yes, I will show you something, and I say share, and where it is. Yes, I'm coming. No, this is not. This is the sharing where it is gone. No. This is, yes. So this I would like to share with you. Just a minute. Where it is gone. Is it visible to you? Yes. Is it visible to you?
No. No.
Now I will show you. Now? Is it visible to you now? Say yes.
No.
No.
What? No. See, now here.
Yeah, I can see now.
Could you hear
Yeah.
the voice?
No voice yet, sir.
Could you hear the voice?
Not yet.
Could you hear the voice? Say yes or no.
No. No, Prof.
No.
Extradition, enforcement of foreign judgment
Prof, are you there?
is limited to civil and commercial
Just a minute,
matters,
just a minute.
and it is governed by treaties, domestic law, principles of comity.
Now you could hear it properly.
Traditionally, a foreign court decision was denied any force beyond its territory, in particular with the rise of sovereignty of states. In a connected and globalized world, the enforcement of foreign judgments became an important subject of conflicts of law, as persons and assets easily move across borders. Since a foreign court decision has no force by itself in another country, the field of recognition and enforcement of foreign judgments evolved to mediate between two competing concepts. First, liberal approach toward enforcing foreign judgments, taking in consideration the legal certainty and harmony in transnational trials, by avoiding repeated litigation and conflicting decisions between foreign courts, plus to make it harder for the losing party to avoid liability. Second, a conservative approach toward foreign judgments, based on reciprocity and sovereign states' rights, by rejecting the enforcement of foreign court decisions, since the litigation abroad can be corrupted, or in violation with the public policy. while criminal cases fall under extradition. Enforcement of foreign judgments is limited to civil and commercial matters, and it is governed by treaties, domestic law, principles of comity, reciprocity, and res judicata. As a result, the number of treaties has grown quickly in order to regulate this conflict of law, and states tend to deny the enforcement of a judgment under the following criterias. First, whether the foreign court has jurisdiction over the case. Second, the judgment has to be valid on the merits and final with no further appeal under the law of the requesting judge. Third, that the defendant had the right to fair trial, was served with notice of the proceedings, had the chance to defend himself before the court, and to appeal the judge's decision, and lastly, that the judgment is not contrary to the public policy of the enforcing country.
So did you hear it, the voice now or not? Yes?
Yes, we hear you.
Because I would like to share this one. That's why I took it out, and that you could hear, because you can also see some of the cases, some of the videos where the foreign judgment, how it can be made and how it can be dealt. So that is the reason I have shown this one to you. So of course I would like
Hello.
this is, I will close this one. I don't know where it is gone. Okay, better I close this one, is enough. So now you understood that how the foreign judgment would be there. So in the next class, I am ready to deal, because I already made it, but the time is going to up, and that is the reason, and I could not make it out, how the foreign judgment would be made under the international instruments. Under the international instrument, like a Geneva Convention is there, Hague Convention is there, Brazil Convention is there. So how the foreign judgment can be implemented over there, we will see in the next class. So meanwhile, if you want to ask anything, you can ask with me, because, yes, anything that you would like to ask me? Are you hearing me?